The Honorable Judges of the United States Court of Appeals in and for the 7th Judicial Circuit. Hear ye, hear ye, hear ye. All persons having business before this honorable court are admonished to draw near and give their attention, as the court is now sitting. God save the United States and this honorable court.
Good morning. Good morning. We'll call my first case. It's 24-2234 Jeff Boat versus Director, Office of Workers' Compensation Programs. And Counsel Marks, you may approach the lectern. Thank you. Mr. Marks, before we proceed, I want to make sure counsel remotely, you're able to hear us okay?
I am. Thank you, Your Honor.
All right. Thank you.
May I proceed?
You may.
Okay. May it please the court. Good morning, Your Honors. My name is Kevin Marks, and I represent the appellants in this case, Jeff Boat Incorporated and the American Longshore Mutual Association, which goes by the trade name of ALMA. We're here today appealing a decision which was made under the Longshore and Harbor Workers' Compensation Act by the Department of Labor. The decision at the trial level, or what we call in longshore parlance the formal hearing, is made by an administrative law judge, and it was affirmed last year by the Department of Labor's Benefits Review Board. We maintain, Your Honors, that the decision was clearly wrong, and we ask that it be reversed. And in weighing your decision, Your Honors, we ask that you look at 4 specific areas of the record. The first area, Your Honor, would be the testimony of the respondent, Mr. Chafers himself. Mr. Chafers was an employee at Jeff Boat from 2005 to 2017, so a period of about 12 years. He worked as a painter and later as a paint inspector. When he was laid off in early 2017, he was laid off as a result of a reduction in force. Jeff Boat was a shipyard in Jeffersonville, Indiana, which is right across the Ohio River from Louisville, Kentucky. Jeff Boat was eventually shuttered, and Mr. Chafers was part of a large group of employees that were laid off as a consequence. Shortly after his layoff, unrelated to this case, Mr. Chafers had another claim for disability. He filed a claim under the Social Security Disability Act before the Social Security Administration, and he asserted that he was disabled for essentially 3 reasons. 1, for HIV, 2, for lupus, and 3, for chronic pain associated with neck and back problems. Specifically with respect to this disability before the Social Security, which the Social Security Administration awarded, he complained primarily of shortness of breath, of lethargy, of getting tired very easily, including things such as climbing stairs. Complained of a cough, a lot of things which were the symptoms that he based his claim later in that year, 2017, when his claim was made for longshore benefits. Now, his claim for longshore benefits was predicated on an assertion that he was exposed to some form of dangerous conditions of his employment, which led to a pulmonary condition. Now, Mr. Chafers, again, these are all uncontroverted facts, will tell you that throughout his period at Jeff Boat, he had many, many tests, passed all of them, that Jeff Boat was a union shop. He had every opportunity to complain to union reps or management and never did so with respect to any pulmonary issues. Furthermore, right before his claim and for about a period of 3 years after, he treated with several physicians in the greater Louisville, the Indiana, southern Indiana area, and there were no diagnoses of any pulmonary problems, or certainly none that were related to work or conditions of employment, and no doctor disabled him. He'll readily admit that he had a litany of other health problems, and if you'll
Should we move to the experts?
Yes, ma'am. Again, we would ask you to carefully review his records because he admits these other various ailments which contributed to the same symptomatology. And
so the ALJ did have an opportunity to review those records as far as the treating physicians?
You're absolutely correct, Your Honor.
Okay. All right.
And those physicians, again, there were 3 of them. None of them made any diagnosis of any work-related, and in fact, with respect to all 3 of them, there were no reports of any work-related symptomatology. So Judge Pryor, you've asked about the experts. The first two, if I may, areas of the record are Mr. Schaefer's testimony himself and the actual treating physicians and the diagnostic imaging and other tests. Again, 1 and 2, those two elements, there's simply no evidence, no basis for a finding of disability. The experts, however, do address disability. The expert which the defense retained was a doctor by the name of William Frazier, a very well-credentialed pulmonologist with over 35 years of practice, thousands of patients, tens of thousands of reviews of the types of tests and imaging that are used in pulmonological cases. Now, Dr. Frazier confirmed that there was no, on any of these diagnostic tests, PFTs, pulmonary function tests, there's no evidence of inability to inhale or exhale. There was likewise, in terms of total lung capacity, it was viewed as normal. After looking at this record as a whole, Dr. Frazier opined that there was no diagnosable lung disease or condition at all, and as a consequence, there was certainly not a diagnosable disease or condition which could be considered work-related or disabling.
Did he acknowledge, though, that some of those paint or chemicals could cause lung problems?
Your Honor, you're absolutely correct. Hypothetically, there is medical literature, or excuse me, at least literature to suggest that, but that actually is apropos of turning to the second expert that, again, 1, 2, and 3, Mr. Schaefer's, the actual medical record of treating physicians and diagnostic tests, and Dr. Frazier. All three of those in the record not only fail to support a finding of disability or any compensable disease or medical condition, but in fact they support the defense argument. So the fourth and final, and to your point, Your Honor, would be the respondent's expert, which was a doctor by the name of Gupta. Dr. Gupta is a practitioner in Connecticut, where respondent's counsel is located. Dr. Gupta never met Mr. Schaefer's. There was no physician-patient relationship established. He never had any clinical exam. He only reviewed records, and he based his opinion essentially exclusively on the subjective complaints of Mr. Schaefer's. In fact, Dr. Gupta agreed with some of the treaters, and certainly Dr. Frazier, that the PFT test were essentially normal, no difficulty in inhaling and exhaling.
You're saying essentially normal, counsel, but didn't even your expert acknowledge that there was at least one abnormal pulmonary test?
Yes, that is fair, Judge. One item of a pulmonary, of the PFT, which contains multiple parts. But having said that, examining it a whole, Dr. Frazier was emphatic that you look at the spectrometry and you look at the total lung capacity, what he referred to as the gold standards, and both of these were normal, and multiple tests, not just one test. In fact, Dr. Frazier reviewed more tests than Dr. Gupta had access to. Even Dr. Gupta agreed that those tests were normal, and those results were normal. Dr. Gupta also agreed that there was no interstitial lung disease, and we can discuss that in detail if the court cares to, but that's an important distinction because that's actual damage to the tissue of the lungs. Dr. Gupta, the treating providers, and Dr. Frazier, again, there's no evidence except for the fact that there was no interstitial lung disease. Again, no damage to the tissue of the lungs that you would see in a traditional work-related pulmonary claim for exposure to chemical irritants or asbestosis or silicosis or the like. Having said that, Dr. Gupta came up with a vague diagnosis of restrictive lung disease, which again essentially just says he, based upon subjective symptoms, has difficulty breathing, he coughs on occasion, and he admitted that all those other factors, the lupus, the obesity, the HIV, the allergy problems, all could cause the same symptomatology. So again, Your Honors, looking at the record as a whole, and those four factors, three of them support the defense, and the only one which supports, respectfully, the ruling of the administrative law judge affirmed by the Benefits Review Board is the expert opinion of Dr. Gupta, a paid expert without any patient-doctor relationship, who relied essentially on subjective complaints with a plethora of actual objective medical evidence, which was contrary to his opinion. Your Honors, based upon that, we would submit that results in manifest error. That's clearly erroneous, and it merits a reversal of that decision. I'll reserve the majority of my time for rebuttal, but Your Honors, if the court has any questions, I'll certainly entertain them, and I'll reiterate that the same symptomatology, the same subjective complaints that Mr. Chafers used to obtain Social Security disability benefits, which he blamed on other medical conditions, were presented in this case for a basis for an award of workers' compensation benefits, again, despite an absence of any conditions of employment causing or contributing to them.
And are you saying, counsel, that receipt of SSI benefits and the claims made in that process somehow make Chafers ineligible for relief here, or are you simply saying it's part of what we should look at when we consider the case as a whole?
The latter, Judge Kohler. You're absolutely correct. Individuals, if they qualify, are entitled to Social Security disability. Individuals, if they qualify, are entitled to federal workers' compensation benefits. Those benefit schemes are not mutually exclusive. However, as you point out, Your Honor, when examining whether or not Mr. Chafers was properly awarded these longshore benefits, it is fair to consider that he made a claim for the exact same symptoms, exact same problems, based upon a whole other set of facts and a whole other set of medical conditions, which unequivocally
are... I'd like you to address the aggravation rule, right? Because I understand what you're saying about the other medical conditions. But I think it's undisputed that Mr. Chafers was exposed to long irritants, right? He testified about the safety data sheets of the materials that he used. I don't think that testimony was rebutted by your client. So I'm interested in, yes, he had these underlying medical conditions, but the test is aggravation. No, did it contribute? So how do you cut through that body of law?
I'll try to very briefly,
Sure.
Judge Maldonado. First and foremost, this was not an aggravation case. This was an exposure case. They weren't saying that he had a pre-existing condition which was aggravated or exacerbated. This is a situation where it was pled and argued that these conditions of employment caused or contributed to a disabling condition. So the aggravation doctrine, I would respectively argue...
But does it need to be pled? I mean...
If you'd like me to address
Yeah.
That's my legal response, Your Honor.
Okay.
With respect to the factual response, this was admittedly an administrative proceeding. Our formal hearings, we call them trials, but we're not bound by the federal rules of evidence. Those are used as a guide. The material data or safety data sheets to which you refer were items which were pulled off the internet by Mr. Chafers. He readily admitted as such. There was no expert which linked any specific material or chemical at all. There was none of the doctors. In fact, Dr. Gupta conceded he can't tell you what made him sick. He's just relying on the fact that the guy told him he was sick. So to the extent that those were a part of the record, I will concede that. But to the extent they were given any significant amount of weight, I would suggest that that was error.
All right, no additional questions. Save the remainder for rebuttal.
Thank you very much, Your Honors.
Thank you.
Good morning, Your Honors. I want just first to thank the court for allowing me to participate virtually. I think that the court has hit on a few of the important facts and also law in this matter. It's well established that the Longshore Act is to be applied liberally. It's a humanitarian act, and it's to protect the maritime workers. And in keeping with that purpose, it is accurate that the law is well established that you don't need to necessarily cause the injury with regard to an occupational disease. It is sufficient if the exposures contribute, accelerate, hasten, or in some way aggravate a
Ms. Simone,
pre-existing.
could you address the concern raised by Judge Maldonado in regards to whether or not the aggravation rule needs to be pled?
Your Honor, there is no pleading requirement that I'm aware of, and it would be almost contrary to the humanitarian effort of the Act to require a claimant to, plead specifically whether it's contributing, hastening, accelerating, or whatnot. So there is no pleading rule that I am aware of that requires that level of specificity. In fact, if you look at the law with regard to the presumption, all you need to do as a claimant is to plead the 920A presumption. You just need to plead a harm and a working condition that existed that could have caused or aggravated the harm. Also, to the court's question, it doesn't need to be the sole factor of the occupational disease. It doesn't need to be something that didn't combine with something else. So the fact that Mr. Chafers had other, health ailments is insignificant. It doesn't matter for purposes of the Longshore Act. Also, with regard to Social Security disability, as the court, I'm sure, is aware, there are a variety of medical issues that the Social Security court would look at, and they look at the record and the medical evidence as a whole. So even though a claimant might, allege a certain medical disease as the cause of their disability, Social Security would award it based on the entire record and the evidence. What I think is most important in this case is to note that the board, the BRB, and this court, the scope of review of the trier of fact is for substantial evidence consistent with the governing law. This court and the BRB is not tasked with the task of reweighing the evidence, resolving any inconsistency, making any credibility determinations. That is the job of the ALJ, the trier of fact, who the law is clear is best able to weigh all that evidence and make a decision. And that's exactly what Judge DeMayo did here. He looked at the evidence, including all the medical records, listened to the testimony, which was uncontroverted by my client, his exposure. There was no dispute that he was exposed to horrible lung irritants, including various oil-based paints, epoxies, sealants, paint thinner that was put into the paint sprayer, antifreeze that was put into the paints in order to make it run in colder weather. He was also exposed to welding fumes. He was exposed to sandblasting dust. He went into contained compartments of the barge unprotected in order to inspect, in order to keep the production line going. So Jeff Boat never disputed the fact that my client had significant, inadequately protected exposure to lung irritants. The other thing I would add is that my client was responsible for a period of time of ordering the paint. So he knew what paints were used in painting barges. And the safety data sheets of those paints were produced by Jeff Boat. All of them, not all of them, I shouldn't say that, most of them, some of them are labeled as lung irritants. So it's not disputed that he had inadequately protected continuous exposure to his lungs. So again, the judge made his decision. He weighed the evidence. He listened to both the medical experts in this case, and he also reviewed all of my client's medical records, which were produced at trial. And in looking at that, he decided, and he very well articulated his reasoning for crediting Dr. Gupta's opinion over that of Dr. Frazier. And again, I think the court hit on it precisely, that he found him to be more convincing and more credible based on his review. Now, I should point out, Dr. Gupta is not necessarily a paid expert who's used over and over again, as Dr. Frazier is, who has a history and is out there as an expert. Dr. Gupta has testified in a handful of cases. He practices near our shipyard, which is Electric Boat. He treats multiple patients who are exposed to maritime substances that are used in building submarines. He looked over his medical records. He talked with him on the phone, and he noted, no, his pulmonary function tests aren't normal. He's got reduced diffusion capacity on all of them, significantly reduced. And his total lung capacity, which was pointed out and acknowledged by Dr. Frazier, is also not normal. He doesn't have normal CT scans, which show the beginning of a fibrotic process. He looked at all of those and he noted that Mr. Chafers has restrictive lung disease and also has emphysema, which is COPD, on his CT scan, and he happens to fall into the category of someone who has emphysema on a CT scan, but it doesn't show it on his FVC and FVC1. All of Mr. Chafers' physicians note lung disease. However, they are contrary in what they say what it is. And it is not necessary, contrary to the assertion of Jeff Boat, that a provider disable a client or a patient in order for that patient to receive longshore benefits. If that were the case, we wouldn't be able to get benefits for most of our clients because most treaters want nothing to do with lawyers, to be blunt. And it's more difficult than it ever is to even get the records from physicians. So if we were required, it's like a needle in a haystack when we do find a treater who's willing to be deposed and to write a report based on linking occupational exposures to lung disease.
I know you can't see the courtroom, Ms. Simona, but I don't know if every lawyer in here doesn't think their doctor likes them.
I'm not saying my doctors don't like us. However, they tend to dodge us, when we say, will you give your opinion? That we might get that opinion, but we're not going to get a deposition. Trust me. They want nothing to do with coming into court and linking that. It's quite often that we have to get an occupational disease doctor. But in this case, Dr. Gupta was able to look at the records, was able to talk with Mr. Chafers, and he actually did look at the CT scan and determined that no, his pulmonary function tests are not normal. His symptoms, he has symptoms. And quite frankly, those symptoms and his testimony is enough to get him the presumption under 920A. And that allows the judge to do the weighing component of under the Longshore Act, in which the judge in this case wrote a very good decision. He looked at everything completely. He linked the testimony of the client with the report of Dr. Gupta, and he found that the record was replete. It was full with uncontroverted evidence that Mr. Chafers was exposed to paint fumes, particles, sandblasting dust, and all sorts of other lung irritants. And based on that, he weighed the testimony of both Dr. Frazier and Dr. Gupta and found Dr. Gupta to be more credible. He also noted, yes, that I think the court brought that up as well. Dr. Frazier acknowledged that exposure to these types of lung irritants can cause and do cause lung disease, restrictive lung disease, sometimes fibrosis, and COPD and emphysema. And the scientific evidence is now quite clear, and literature has come out since this decision that 14 to 15% of COPD is caused by occupational exposures. It's not just smoking, as a lot of people assume. So I think the most important thing is that the scope of this court is limited to review the record, not to reweigh the facts, which Jeff Boat continually requests that the court do. It's similar to the BRB. The record is the record. The facts were determined by the trier of fact, who was best able to determine credibility and to make the decision based on the evaluation of the evidence at hand. It was Judge DeMayo's scope of it was his job, actually, as a trier of fact, to review the evidence. It was his job to determine credibility, and it was supported by substantial evidence as determined by the Benefit Review Board, and the decision must stand. This court is not in the position, as the appellant would have you believe, to reweigh the evidence, to reconsider both decisions, to look at the specifics of the medical records. That's been already done by Judge DeMayo, and for that reason, I believe that the decision should stand.
Thank you. Did you want to address briefly the concern regarding attorney's fees and whether or not the director might have missed a few of the overcharges?
No, Your Honor, that's fine. I stand by my brief.
All right, thank you. Mr. Marks, any rebuttal?
Yes, Your Honor.
All right.
Your Honors, if I may, first, Ms. Simone referenced the liberal construction that the Longshore Act is to be afforded. Uncle, I yield. I've practiced for nearly 30 years in Longshore. It is a liberal act. It was established in 1927. If anyone wants to have a cup of coffee about maybe getting the Congress to amend it, I'd be happy to entertain it. But having said that, this case presents an exception. I'm used to fighting with one hand behind my back on that. In this particular instance, despite the liberal construction, the record shows that Mr. Chafers should not have been awarded benefits. Ms. Simone also talked about the presumption under the Act. I'll yield to that as well. The 20A presumption was established, as Judge DeMayo and the BRB acknowledged. They also acknowledged that we rebutted that. So we're right back to a standard that we're all familiar with in district court, and that's just a simply weighing of the facts. And so the burden remains with Mr. Chafers. With respect to the actual illness itself, again, contrary to what Ms. Simone said, Dr. Gupta testified very clearly that he agreed with Dr. Frazier that there was no CPOD and that there was also no pulmonary fibrosis. He also agreed that there was no interstitial lung disease. And at the risk of repetition, that's very important. Interstitial lung disease, interstitial means intervening. It's the actual tissue. Our lungs are comprised of tissue and then little pockets, little sacs of air that we all rely upon. When you have a typical disease or damage to the lungs that's employment rooted, that there's damage to that tissue. It's undisputed. There was no damage to that tissue. So what we're relying upon are subjective complaints of limitations in breathing. So again, I would re-urge the court that when we're talking about the record as a whole, if we look at the medical evidence, it supports the defense on this. If we look at Mr. Chafers' own testimony, it supports the defense on this. Dr. Frazier's interpretation, which obviously I support and believe
I
is
noticed that
credible.
we're out of time. If you could wrap up.
Thank you very much.
Thank you.
Your Honor, again, we pray for a reversal and a finding that Jeff Bode and Alma should not be liable for permanent partial disability or medical benefits under the Longshore Act. Thank you very much for your time.
Thank you. Thank you to both counsel.
Thank you, Your Honor.
Thank you, Dana.
All right, the court will take the case under advisement, and we call our next case, case number 23-1641, Alice Flowers versus Brian Bell. All right. Mr. Cloverman, when you're ready, you may approach. Thank you. You may proceed.
Good morning.
Good morning.
May it please the court, my name is Scott Glauberman. I'm the court-appointed amicus here today on the side of the plaintiff appellant, Alice Marie Flowers. This case began when officers from the Sheriff's Department in Madison County, Indiana, pulled over the plaintiff, Ms. Flowers, in her car. They detained her, and they held her long enough for another officer to arrive to serve her with a warrant that was, everyone agrees, facially invalid. The warrant was never signed by a judge, it was never approved by a judge. In the place of the judge's signature, as you no doubt saw in our brief, where we reproduced the warrant, there's a large blank space. And the officers in this case have never contended that this warrant had judicial approval. The officer who served the warrant is named Brian Bell. He was at the time a captain in the Sheriff's Department. He was the leader of the other 4 officers who were defendants in this case. Those are the officers who initially stopped Ms. Flowers. The Sheriff's Merit Board, as a result of the events that we're here about today, found that Captain Bell violated Ms. Flowers' constitutional rights and, as a punishment, suspended him without pay. The district court, however, in this case, held that Ms. Flowers had no claim against any of the officers, Bell or the other 4. The district court's judgment should be reversed. In our brief, we identify 3 illegal seizures that took place that day, one after another, to Ms. Flowers. Those were the stop, the detention, and the warrantless seizure of the phone. I'd like to start with the third, if I could, the warrantless seizure of the phone, because it naturally brings up the other 2. To recall, the other officers stopped Ms. Flowers, held her for 10 minutes, waited for Captain Bell to arrive, and as planned, as he had arranged the day before, he then went to the scene and served her with this warrant, this invalid warrant. When he walked up to her truck, he told her, "They stopped you because I told them to stop you. I have a warrant for your phone." Ms. Flowers objected, said that she didn't want to turn over her phone, and Captain Bell grabbed it. In his summary judgment motion, Bell's only argument to justify the warrantless search was the plain view doctrine. He relied entirely on it. That doctrine has 3 elements. Captain Bell cannot establish 2 of the 3 elements. The first of those is that he cannot have achieved plain view of the item at issue, the item seized, via violations of the 4th Amendment. That comes from a Supreme Court decision in 1990 called Horton. It's been in other decisions, it's been in this court's decisions. It's very well established. Here, Bell's seizure of the phone was due to 3 different violations of the 4th Amendment. The first of those was the stop, the illegal stop. There was no valid reason for that stop. No admissible...
Did the officers, though, represent that they stopped for registration on the vehicle?
That's correct, Your Honor, but there's no admissible evidence that shows that. There was no ticket to Ms. Flowers. There was no warning to Ms. Flowers. There was no testimony in the district court that that is, in fact, what happened. All we have in the district court on that subject is Bell repeating what another officer told him.
And they're allowed to rely on what other officers tell you during an investigation. Isn't that correct?
You can rely on it, certainly, but you can't, in the course of doing the investigation, but you can't win summary judgment based on repeating what someone else said they saw.
Just want to make sure the representation is correct. So that is the evidence, though, that was in the record, that Captain Bell relayed to the district judge what he had learned from the other officers.
He said, I heard from Officer Saylor that they pulled her over for some reason related to her license plate or registration.
So there was no report prepared by those officers that would substantiate that, other than Captain Bell's report?
Well, the statement we're talking about now comes from his affidavit in support of summary judgment.
That's what I'm asking.
He did have reports, police reports.
The other two that conducted the stop, there were no reports?
No, not that I'm aware of.
That's what I want to make
Not that
sure.
I could see in the record.
Okay.
The reason that he gave in his reports and in his affidavit reflects a shifting explanation. In addition to being maybe because it's hearsay, it changes over time. In his March 2nd report, he said she was pulled over for driving without a registration. The car wasn't registered. In summary judgment affidavit, he said she didn't have a visible Indiana registration. And in his brief to this court, his opening brief to this court, he said her license plate was not visible. So the explanation has changed over time, but in any event, has always come from just one source. That source is Officer Saylor. The only admissible evidence before the district court about why she had been pulled over was his statement, Bell's statement, to Ms. Flowers, captured on videotape, which is in the district court's possession, where he says, they stopped you because I told them to stop you. I have a warrant for your phone. The warrant, which as we all know turned out to be invalid, was the reason for the stop. Bell had planned that earlier. He had planned it the day before. In his reports, I think it's his February 26th report, he recorded that he preferred not to serve the warrant at her home or at her business. He wanted to do it while she was in a car. And therefore, that's in fact how they did it. The entire purpose of this exercise was to serve the warrant, and there was no admissible evidence that it was done for another reason.
Getting back to what's in the record,
Yes.
Is there anything in the record from Ms. Flowers representing that her registration or license plate was visible? Is there anything at all?
I don't recall any statement on that subject off the top of my head. But of course, it's not her job to disprove it. It's their job to show that that was the reason for the stop. That in fact, they had probable cause for a traffic stop based on admissible evidence. And that they completely failed to do.
But for her to survive summary judgment, I believe that's where Judge Maldonado was going. She has to show that there is a material issue of fact in order to survive summary judgment. And if the representation made by the officers is that we had reasonable suspicion to stop her, and that being some type of vehicle violation, then the purpose, even if it was to serve the warrant, case law is clear that we don't consider that as long as there's reasonable suspicion. So with the question really drilling down to, did Ms. Flowers contest that the officers had reasonable suspicion, that the reason that they gave should not be relied on by the district court?
Well, and to that I would say two things, Your Honor. The first is I think it's an important distinction about whether the officer's evidence was admissible. Because this court has held many times you can't get summary judgment based on inadmissible evidence. Summary judgment is in effect a stand-in for the trial. And you can't win it based on evidence you can't present at trial. And that's all the officers had here. The second thing is, I do recall Ms. Flowers.
There's nothing, though, to suggest that that affidavit relied on by the district court was a sham affidavit. That's kind of the argument if we pull that thread a little bit.
I'm sorry, I'm not sure what you mean by a sham affidavit.
Suggesting that what Captain Bell represented his affidavit, that the officers had reasonable suspicion to stop her, that was not contested below.
Well, it was contested in the sense that I do recall Ms. Flowers filing papers that said that at the scene, she told Saylor, the officer we're talking about, that she did have proper registration, and of course, she kept the registration papers in her car. So I do recall her saying that in particular.
And that was in response to the motion to dismiss. Was anything filed in response to the motion for summary judgment?
I don't recall off the top of my head where she made that statement or
Okay.
if she made it more than once.
Okay.
But, Your Honor,
No, finish. You're fine.
I was just going to say, I do think the point stands that the officers Bell needed admissible evidence and didn't have it. And his story changed over time. It was not a consistent story about why she'd been pulled over.
Moving to the next step in the record, I think it's probably what you were referring to as the over-detention. Is it clear from the record that this isn't the type of case where there's a drug dog sitting right by and the stop isn't elongated? The stop is elongated specifically so that Bell can show up. Is that correct?
That's correct. There is videotape of this, as I mentioned a short while ago, and Bell's records state that there was 10 minutes in between the stop and when Bell arrived on the scene. The videotape shows approximately the last 8 minutes of those 10, and we know Ms. Flowers received no ticket or warning. We know from the videotape that there is no activity related to a traffic stop about a plate or registration. Everyone is just sitting around waiting. Ms. Flowers asks if she can leave, if she's free to go. The response is not audible, but it's evidently no, she's not free to go, because her next question is, why? What crime am I being detained for? Again, the response is inaudible. But we know she was compelled to sit and wait for 10 minutes with apparently no other activity, waiting for the officer to arrive, for Bell to arrive.
In pulling that thread, if that's the independent constitutional violation and also goes to invalidate any claim under the plain view doctrine, you were appointed, we appreciate your service as amicus, but has Ms. Flowers put that at issue? Under party presentation principles, could we reverse based on that line of argument?
She did put it at issue. In her initial complaint, the pro se complaint that started the entire case, she complained about the officers falsely imprisoning her, falsely keeping her and not letting her leave. And she certainly elaborated on that in other filings that she made, including in an attempted amendment to the complaint a few weeks after the motion to dismiss was filed. I don't think there's any doubt she has consistently complained that they wouldn't let her leave. And it's backed up by the videotape of the scene. If the court has other questions, I'm happy to answer them. Otherwise, I'll reserve the remainder of my time.
Thank you.
Thank you.
Thank you. Good morning. My name is Alex Emerson, and I represent Brian Bell in this appeal. Brian Bell, as counsel told you, executed an unsigned warrant and seized her phone during a traffic stop.
Are we accepting that the warrant was invalid?
Absolutely.
All right.
Yes. And so that's part of this situation is you're not going to hear me say, and I don't think you'll hear even Captain Bell say, that his police work that day was good. He served an unsigned warrant. He had to take his medicine for that. He was suspended by his boss, Sheriff Mellinger, for 2 days for that. Notwithstanding that suspension and the
How
service.
do we get to the arguments that were raised this morning
Sure.
in
certainly.
regards to whether or not any of these arguments have been waived?
Yes, Your Honor, they have. And I am cognizant of the Seventh Circuit's admonition to district courts with respect to pro se pleadings. But I think one important fact or one important legal aspect of this is by the time we got to the summary judgment motion, the claims had been narrowed solely to Brian Bell's seizure of the phone. Now, in the briefing, there was an issue with respect to, brought by counsel, as to whether or not we're talking about both the seizure, which was, I think Bell's interaction was about 2 minutes with Ms. Flowers, as seizure of her person, in addition to the seizure of the phone. But in any event, it's Bell's conduct that's at issue with respect to the motion for summary judgment.
But for him to be legally present under the plain view doctrine, he had to be legally there. And so are you suggesting that the traffic stop, whether or not the traffic stop was delayed longer than reasonable to where it became an unreasonable seizure, is not at issue?
Not at summary judgment, Your Honor. No, I don't believe so.
There was a motion to dismiss that was filed.
That's
and
correct.
so are you suggesting that she did not appeal the judge's decision in regards to the motion to dismiss?
It's a little bit unclear, Your Honor. With respect to the notice of appeal, she only attached, as the appealed order, the order on the summary judgment. In her initial brief, she makes a single sentence saying that the district court erred in dismissing the other defendants at the motion to dismiss stage. So, yes, I believe that that was an issue. And with respect to, I believe that she waived the issue by not indicating that she is actually appealing the dismissal of the other officers, and she fails to present any sort of coherent argument that it actually discusses the actual order on the motion to dismiss. So what we're looking at here is the order on the summary judgment proceedings.
But I think we really have to drill down on step one of the plain view doctrine, and that's where counsel spent primarily all of their time this morning as to whether or not Captain Bell was lawfully present at the traffic stop. And so the only way, or the suggestion is, the only way that we can answer that is if we can determine whether or not the traffic stop was delayed unlawfully.
Understood, Your Honor. I don't know that Ms. Flowers has ever asserted with respect to the unlawful length of the detention. And once we start talking about the plain view doctrine, Brian Bell's interaction where he pulled in front of her, which is the moment that she identified in the complaint as not being able to leave, as being seized, from that moment, it's about 1.5 to 2 minutes where he walks up, they have a discussion, and he snatches
Our
his phone.
case law is clear. The Supreme Court has directed us that you don't have to, during a traffic stop, stick out the Constitution for the law enforcement officer to know when the mission of the traffic stop is concluded. So let's directly back to the question of whether or not the traffic stop was unlawfully prolonged. It's not up to Ms. Flowers to suggest that you are violating my constitutional rights. And so was the mission of the stop concluded before Captain Bell arrived?
If the sole mission is a traffic violation with respect to the license plate, yes, we have problems with respect to the seizure, because the video shows that they don't take action, whether it's approaching the vehicle, whether it's writing a ticket, whether it's writing a warning. The officers don't take that step. And so if the reliance is on that license plate, yes, there are problems with the other officers' seizure of Ms. Flowers. I will agree with that. Now, with respect to whether Brian Bell, whether her seizure for the purpose of seizing the phone was improper, I do not agree with that. I think that it was proper. And I think the reason that we can give is because at the end of the day, what we're looking for is probable cause to believe that Ms. Flowers had evidence that could aid in a conviction. And that essentially has been unchallenged. And once you have probable cause, not only in this context, but in many other contexts.
So are you suggesting that the approaching of Captain Bell was attenuated from the illegal activity of the other two officers?
Pardon me, Your Honor.
Are you suggesting that once Captain Bell arrived, that his arrival is attenuated enough that it's not tainting his presence of being at the traffic stop? There's enough time in between? I'm trying to
I'm afraid I don't understand.
trying to disconnect why we're able to address Captain Bell's appearance at a traffic stop that you have accepted this morning that was unlawful. So I'm trying to make sure that I appreciate the legal bridge.
Understood. I think Brian Bell, and any law enforcement officer, has the inherent power to detain an individual for achieving whatever the purposes of that legal stop ends up being.
So we're talking about a cell phone here, and the Supreme Court has ad nauseum talked about what that means and how many people have just significant amount of information in their cell phone. Wouldn't your argument essentially mean that anyone who is even a bystander witness to a crime and has a cell phone on them can be stopped and seized by the police so the police could get that cell phone?
Yes, I believe that the Supreme Court law would say if there is probable cause to believe that that has evidence of a crime that could aid in a conviction, the phrase is aid in apprehension or aid in a conviction, then yes, assuming that the officer can meet the other elements of the Plainview Doctrine, then a seizure of that cell phone would be appropriate.
We don't get to the Plainview Doctrine yet because you're stopping someone to get to the phone.
I understand that, Your Honor. And there is the elephant in the room is the fact that at all times he believed that there was a lawful search warrant here, and we didn't have that. And so it is a little bit of a timing issue, if you will, because at the time that the other officers pulled behind Flowers and put on their lights, there was no lawful valid warrant in existence. Now, they might not have known that at that time, but there wasn't. So once Bell gets there, though, I think we're in the clear, so to speak.
That's what we're trying to get you to talk us through. Why are we in the clear?
Because if Bell can show that there's probable cause for the seizure of the phone, or probable cause to believe that the phone contains evidence of a crime.
But he hasn't, at the time that he arrives, she is being unlawfully seized. So
With respect to if the purpose of the stop is to seize her phone, then no, I don't believe that she is being unlawfully stopped.
they didn't have probable cause to stop her car for seizure of a phone.
I think, Your Honor, it would be reasonable to believe that she has a phone. She has her own phone on her person at the time of the stop.
Reasonable suspicion for a traffic stop and probable cause for a search. That's two different levels of suspicion that is needed. And so the suggestion below was that there was reasonable suspicion for a traffic stop. Now you're suggesting that they needed, or they had probable cause to stop that vehicle because it was trafficking a cell phone. And so this is the first time I'm hearing that the suggestion is there was probable cause to stop that vehicle to search for criminal activity afoot. Is that what you're suggesting this morning?
No, Your Honor. No, if that's how that came out, that's not my intention at all, to say that they had probable cause to pull her over and search her vehicle.
You only need reasonable suspicion for a traffic stop.
Correct, Your Honor. Yes. I
And
agree
so
with
you suggested just a moment ago when they stopped that vehicle, they had probable cause that she had her phone with her.
The probable cause reference goes to what is required to effectuate a warrantless seizure of an item.
But in order for it to effectuate a warrantless seizure of an item, plain view exception, the first step is that the officer has to be lawfully present. And
Yes,
so
sir.
we're trying to get over the first hurdle. Why is the officer lawfully present? And then we can get to Judge Kolar's question in regards to whether or not law enforcement officers have probable cause to seize everyone's cell phone in the courtroom.
Yes. First, with respect to the question as to whether Brian Bell was lawfully there at the moment at the time of the seizure. Yes. And the reason is, as set out in the briefing, the main focus of Fourth Amendment jurisprudence with respect to the plain view, it is not, I will argue with counsel, it is not whether they violated the Fourth Amendment in achieving that location. It's whether or not they can physically be in the location. And the cases cited in the briefing talk about whether or not the officers properly went into someone's house, which has heightened requirements, heightened concerns from a constitutional perspective. This occurred on a public street, and Brian Bell, in driving to the location of the traffic stop, did not do anything, did not put himself in a physical location where he wasn't allowed to be with respect to the Fourth Amendment.
The car wouldn't be there unless she was unlawfully seized.
I understand that the seizure, if it's solely based on that license plate issue, then yes, I agree with you. And I
So
agree
when
that
she
the
asked the question in her complaint, "You're unlawfully seizing me," what other reason is that car still there lawfully when Captain Bell arrives?
Captain Bell has the inherent law enforcement power to briefly detain somebody to effectuate a seizure based on probable cause.
I might be repeating what Judge Pryor's getting at here, but it seems to me like what you're saying is law enforcement could wait until someone's out of their house, detain them, and without a warrant, take their cell phone. And we've got Raleigh v. California. We have, I mean, it's not just is the law enforcement officer in a public place where the law enforcement officer is allowed to be. You have a detention. You have an over-detention that made the person whose cell phone Bell was seeking be in that location. I don't know what the limiting principle of your argument would be.
I understand. I think, as I said, if we're talking about the detention just in the scope of the registration or the license plate, we have problems, certainly. But if we were talking about the detention for the purpose of seizing the cell phone, then I don't think there's any evidence in the record that Captain Bell delayed or improperly prolonged that aspect as it's set forth in
Counsel
his...
from the other side said that she was sitting there for 8 minutes waiting for Captain Bell to arrive, and she said, "Can I go? Can I leave?" So that's what we have in the record. Her asking, in essence, unartfully, of course, because she's not a lawyer, "Are you unlawfully detaining me? Why am I still here?"
Yes, Your Honor. I believe that 8 minutes is reasonable to radio to Captain Bell and have Captain Bell report to the traffic stop. He's on patrol in the city of Anderson. And
We
so-
at the Supreme Court, though, has directed us that once the mission of a traffic stop is done, you must release the driver.
Understood, Your Honor.
And so I understand radioing and telling Captain Bell she has been stopped. What part of the traffic stop was still happening during those remaining 8 minutes until he arrived?
I think that the actual fact of the matter is that they believe that he was coming with a valid warrant.
So nothing in regards to the traffic stop?
Well, ultimately, the end result is the same, the seizure of the phone.
No, it's not the
based on-
same. Is there anything else in regards to the mission of the traffic stop after the first 2 minutes?
Other than simply waiting for Captain Bell to arrive, no.
All right.
Thank you, Your Honor.
Thank you.
With the court's permission, I'd like to briefly address two topics in my remaining time. The first is whether any of the claims here should be held to be waived because they weren't presented. I think the answer to that is no. I do believe that the issues raised in our brief, filed after the parties filed their briefs, are all fairly raised, especially given that Ms. Flowers is a pro se litigant. And even to the extent they're not...
What would you direct us to in the record to demonstrate that the question of whether or not she was unreasonably detained was raised below?
Well, I point you first to her complaint where she said she was falsely imprisoned by the officers. I think that alone establishes exactly what she's talked about. But if you like, Your Honor, I'd be happy to file a supplement afterwards that explains exactly where in the record each of those mentions comes up of that particular issue.
And counsel, just one,
Sure.
I'm also concerned, was it raised in her appeal?
She appealed the judgment, Your Honor, and she did it as a pro se litigant, and she does mention it in her brief, in one of her briefs in this court. And I think for a pro se litigant, especially one where this court's
She
appointed...
raises, what do you mean? She raises what? You said she raises...
I believe
it?
she raises the detention in
The
her
detention.
brief. And for a pro se litigant, especially one whom the court has now appointed a lawyer to come in and more fully explain, I think that's enough. I think that does do the job for her. But this court also has plain error review, even if things were not raised as fully as the court thinks they should have been. There is plain error review. And some of the errors here, in fact, I think all of the errors here were very plain. I'll give one example because time is very short.
You're out of time, counsel.
May I finish?
You may.
Thank you. In the dismissal order, the district court held the other officers were not responsible for the initial stop. They were merely present at the scene when Bell stopped her. That is factually wrong. Everyone knows that's wrong. Bell agrees that's wrong. But then in the summary judgment ruling, the district court said Bell could not be responsible for the stop. It was the other officers who did it. So everybody got out on the stop on the grounds that everybody else did it, but they didn't do it. Bell was responsible for the stop not because he was present, but because he directed it. It was his plan to have them stop her, and that's what he did. If there are no other questions, Your Honor, we'd ask for reversal of the judgment.
Thank you, counsel, and thank you to both counsel, and particularly to Winston Strom. We know that you were appointed amicus on this, so we appreciate your service to the court.
Thank you. If I could, I'd like to add my thanks to my colleagues, Brent Winslow and James Randall, who worked closely with me on it.
Thank you.
Thank you.
All right, we will take the case under advisement, and we move now to case number 324-2056, Joshua Harris et al. Versus W6LS et al. Mr. Crocker, all right. If you may begin.
Thank you, Your Honor. It please the court. My name is Paul Croker, and I'm here today on behalf of the defendants, W6LS Inc. and Caliber Financial Services Inc., both of whom are wholly owned and operated economic arms of the Oto Missouri tribe. In this case, we are appealing the district court's denial of the defendant's motion to compel arbitration. In this case, there is no dispute, and the district court found that the parties entered into a contract, loan agreements, and that there was an arbitration agreement within those contracts that provided that the disputes at issue here that the plaintiffs have raised fall into the scope of those arbitration agreements. There is also no dispute and the district court found that the broad delegation provisions clearly and unmistakably delegate all issues, including plaintiff's claims and all gateway issues, including arbitrability, enforceability, interpretation, and validity of the loan agreements and the arbitration agreements to the arbitrator. Therefore, the threshold issue for this court to decide is whether the broad delegation provisions are enforceable. That is, who should decide plaintiff's claims and the gateway issues. We submit the delegation provisions are enforceable, and the gateway issues should be submitted to arbitration, because there's nothing unusual or unique about the delegation provisions. The delegation language has been enforced by the Supreme Court and federal courts across the country.
But counsel, when this was signed, when this delegation provision was agreed to, the tribal code that the provision is referring to, at least if I'm reading the record correctly, it didn't exist. The code was, the date that it became public and enforceable was after the signing of this agreement. So what were the plaintiffs agreeing to?
Your Honor, are you referring to the contract code?
Yes.
So, Your Honor, there was tribal law in place regarding, there is a robust regulatory environment. There is a financial services law at the tribal law level that was put in place when the tribe entered into the business of making consumer loans. Now, to your point, the contract code was not in place at that time. There was.
So what was the plaintiff agreeing to on choice of law, on how this was going to be decided?
Sure, Your Honor. In this particular case, the governing law provision provides for federal law and for tribal law to be the governing law. And so as we look at this issue, when we're looking at the delegation provision, there's no issue as to whether or not there was a contract formed. The plaintiff's claims count on there being a contract formed. There's no dispute, and the district court found there's contract formed. So we don't need to look to state law with regard to any sort of contract formation issues. As this court found, I believe in KFC, it is federal law rather than state law that determines who is going to decide the issues of the plaintiff's claims and the gateway issues. And so we don't need to look at any sort of state law or the tribal law for purposes of determining contract formation.
But we are going to need to look at that when we say, okay, is the delegation clause, what is the delegation clause saying, and is the delegation clause itself unconscionable? And what was being agreed to? What was the choice of law? What was that contract code? It seems to me that at the time the plaintiff signed the arbitration agreement, including the delegation agreement, the contract code didn't exist. So you'd have potentially some federal common law, but then the tribal law could come in after the time of the signing of the agreement and change the parties' rights and how the delegation clause is to be interpreted.
You know, I would point out that the contract code has retroactive effect, which sovereigns can do. They can put in retroactive effect as the contract code. And here, there's nothing unique or odd about the contract code. It is formed after many other state type of contract codes. So there's nothing unusual for the arbitrator to rely upon when deciding any sort of issues. But I think what we're looking here really is whether or not the plaintiffs ever specifically challenged the delegation provision. And I submit to you that they did not. The challenges are to the arbitration agreement as a whole or to the loan agreement as a whole. What the arguments that they raise are that the interest rate is outside of Illinois law. That's not a specific challenge to the delegation provision. They argue that the choice of law provision doesn't include Illinois law. That's not a challenge to the delegation provision. And they raise Illinois public policy. That again, that has no bearing on the delegation provision that's before this court.
Well, when we looked at the record in regards to the opposition to the motion to compel docket 33, in particular, there's some argument there at pages 11 and 12 where they suggest that the body of law that Judge Kolar is referencing permits enforcement of either the arbitration clause or the delegation clause. a negated application of both the agreement as well as the delegation clause in particular. And they also raised it again on page 12 in opposition to the motion to compel. And so what do we do to address, are you suggesting that those arguments were insufficient or not properly developed?
Yes, I would submit to you that those are not specific challenges to the delegation provision. It has been held in Dunn in the 11th Circuit and Bryce in the 9th Circuit that a challenge to the choice of law provision as it is applied to the arbitration agreement as a whole is a challenge to the arbitration agreement and not as a whole and not a specific challenge to the delegation provision itself. And in Dunn, the 11th Circuit explained it's premature to resolve the choice of law challenges at the arbitration enforcement stage or at the delegation stage, that the choice of law question must be decided in the first instance by the arbitrator. And that's done in the 11th Circuit, and that's quoting the Supreme Court, Vamar Cigarros y Ria Cigarros. It would also be improper for the district court to look downfield to say, well, what might happen if we enforce this choice of law provision? Might it avoid liability? And relying on Rent-A-Center, the 6th Circuit, the 9th Circuit, and the 11th Circuit have all held that an argument of this nature, that there might be speculating whether or not there might be liability avoided in arbitration, is improper, and it's not a specific challenge to the delegation provision itself as required by Rent-A-Center. So if we also look at other challenges that were made with regard to public policy, plaintiffs have said that the interest rates were outside of what is allowed by Illinois law, that the governing law provision doesn't include Illinois law. As this court held in KFC v. SNAP, public policy challenges to the agreement are a defense to enforceability of the agreement as a whole and are delegated to the arbitrator. Again, all issues regarding enforceability here have been delegated to the arbitrator. If we look at the key here too, is that when we get into arbitration, the plaintiffs will have the ability to raise all of these issues. It is very clear from the delegation provision that the arbitrator can consider any challenge based on any form of law, whether it be Constitution, whether it be common law, whether it be statute, whether it be Illinois law. So there's no concern here that the plaintiffs will not be able to raise these challenges, including public policy under Illinois law, in arbitration. They have the opportunity to raise those. And if I could speak a little bit to the effective vindication doctrine, this court cited to footnote 5 of Viking River, which is what the district court and what plaintiffs are relying upon to say that there's this huge sea change as to the effective vindication doctrine, and has been expanded beyond federal law to include state law and protection of state statutory rights. This court cited that footnote in Rogers-Ragier, and as recognizing that the FAA only applies to the substantive validity and enforceability of the provisions governing the arbitration itself, and not any other provisions in the contract. It didn't cite it for the proposition that somehow the effective vindication doctrine has been wildly changed in a footnote to a Supreme Court opinion that doesn't even reference the doctrine by name. So, and if we look at Viking River, in that case, that again is what the district court and the plaintiffs rely upon, is this huge sea change as to the doctrine. In that case, the Supreme Court held that the defendant could compel arbitration of the state law claims and dismiss the plaintiff's California representative claims. So in a case where the Supreme Court is enforcing an arbitration agreement, it certainly isn't of state law claims, it certainly isn't finding that there is a huge shift in the doctrine. If that would have been the case, then the court would have applied the doctrine, the case would have moved forward in litigation in a court, not in arbitration. If there's no other questions, I'll reserve the rest of my time.
All right, thank you, counsel.
Thank you.
Mr. Edelman.
May it please the court, counsel. I'm Daniel Edelman, representing the plaintiffs. The court was concerned about the logical basis for the delegation provision, which where the arbitrator is directed to apply tribal law and applicable federal law. In the Rogers-Rosier versus American Queen decision, this court made it clear that state contract law is what creates contracts. The Federal Arbitration Act prohibits state law from discriminating against arbitration contracts, treating them less favorably than other contracts. Here, however, the defendants provide that state law doesn't have any application. Can tribal law be substituted? No. Under this court's Jackson versus Payday decision, and under the Supreme Court's Plains Commerce Bank decision, an Indian tribe does not have authority to prescribe rules of law governing transactions which do not take place on the reservation with non-members. Furthermore, Jackson holds that it's a matter of subject matter jurisdiction and that it applies to both adjudicative, administrative, and legislative acts by the tribe. So, tribal law, which was not issued at the time the loans were obtained, but whatever its content, cannot be applied in this case. These loans do not occur on the reservation. While the lender purports to be wholly owned by a tribe, the tribe is in Oklahoma. The actual premises of the lending activities are in Kansas, in Missouri, and Texas. The computers that the Illinois resident communicates with in the course of obtaining the loan are in California. What is in Oklahoma is a private mailbox. The reason this is done is that the
counsel, where in the record are you getting those locations?
Those were alleged in the complaint. At no time did the defendant deny that those are the locations. They were based on things like job advertisements placed by the defendants, which indicate where the place of work, the intended place of work is. It's not on the tribe, on the reservation. Anyway, the reason all this is done is that these loans are made at just under 500%. The Predatory Loan Prevention Act caps rates at 36% if you have a bank or credit union charter or a license from the state of Illinois. The rate is 9% if you do not have one of those. The statute specifies in geographic terms.
What do we do, though, Mr. Elman, that the suggestion by counsel is that we can't get to this question until we determine whether or not the court should have or erred in answering this question without sending this to arbitration?
Under the prospective waiver doctrine, I believe that this court can. The Arbitration Act does not authorize what amounts to an advance waiver of rights under, in this case, Illinois law, under RICO, because there is RICO criminalizes the making of an unlawful debt.
Is there any circuit that agrees with your reading, extending Vica Rivers Cruise to that of state rights, substantive rights?
I believe it was, the Second Circuit did so in the Oto, Missouri case against the State Department of Financial Institutions.
I'm sorry, counsel, can you give me that citation? It's a little hard for me to pick you up as far as...
I'm sorry. Oto, it is 769 F. 3rd 105.
All right.
Where the same tribe sought to enjoin the New York Department of Financial Services from enforcing its laws, the New York laws against usury. I think that when one looks at as the court below did, at the briefs in the Viking River case, it is clear that the Supreme Court was applying the prospective waiver doctrine to all statutory rights, state and federal, which in this case are inextricably intertwined because of the criminalization by federal law of transactions that are usurious under state law, where it's at least twice the lawful rate and made by somebody in the business of making such loans. The defendant's argument would basically eliminate the prospective waiver doctrine, and I believe that Judge Jenkins was correct in her application of it. Going back to the substance of the delegation argument, most courts, Gingras, Hengel, have held that it is permissible to challenge the delegation provision on the same grounds as the arbitration agreement as a whole, at least where the problem is prospective waiver of rights. In addition, we have tribal law which does not exist, which cannot constitutionally be applied by a tribe to people who are obtaining loans in Illinois, who are obtaining loans over the internet from businesses which are nowhere near the reservation. The loans are not made to members of the tribe. The purported law does not meet the restatement definition of law at all. The restatement requires that the law be applied within the by the adjudicated authorities in the territory issuing the law in the ordinary course. Here we have the issuance of a piece of paper, the sole purpose of which is to be used against residents of Illinois and other states, and to authorize the commission of acts against them which are either illegal or outright criminal. That's not something that, this is just not tribal law in any meaningful sense. The defendants relied on a couple of cases. Bryce versus Haynes was a split decision that was vacated upon the grant of rehearing and then settled. I submit that this is not entitled to significant weight as recognized by the court below. Dunn versus Global Trust Management is an unpublished 11th Circuit decision. I believe it is the minority view, and most importantly involved a totally different statute. The Florida statute in that case is quite different from the Predatory Loan Prevention Act. The PLPA specifies what transactions it applies to. It specifically applies to loans made over the internet to Illinois residents. It states that the laws that such loans at more than 36% are void, and that the lender has to give back whatever money they receive pursuant to such a law. The defendants are basically reaching for concepts which have legitimate purposes, but are trying to apply it to a completely illegitimate series of transactions, starting with the proposition that that an arbitrator should be applying tribal law which at the time of the loan didn't exist and cannot, and even if it did exist, cannot be applied under the circumstances of this case. The decisions, particularly from the Second and Fourth Circuits, uphold, Second, Third, and Fourth Circuits, uphold the application of the prospective waiver doctrine to this kind of scheme to evade state law, and I submit that the decision below is correct, unless your honors have some other questions. That concludes my remarks. Thank you.
Thank you, counsel. Any rebuttal? All right.
May I proceed?
You may.
I think it is clear from opposing counsel's arguments that we're getting into the merits, and all of his arguments are getting into the merits as opposed to challenges that are specifically directed to the delegation provision. Again, there's nothing unusual or unique about the delegation provision. It allows the arbitrator to entertain challenges of any sort of law, whether it be Illinois law, constitutional law, whatever the case may be. And the reference that was made by opposing counsel with regard to I think he was referring to the Second Circuit Gingras case. The Second Circuit made it clear after that case that the effective vindication doctrine is limited to the protection of federal statutory rights, and that was in the Doctors Association case.
And do you have that citation?
I do. That would be 794 F Appendix 91 at 94.
794 F Appendix, what did you say? I'm sorry.
91, and then the pinpoint side is...
Also, so it's an unpublished decision?
That is correct.
It was an unpublished decision that you are representing that limits the reading of the Second Circuit?
Well, Your Honor, I would also look to Supreme Court precedent on this issue. In Italian colors, it was, in that case, while the district court tried to not pay attention to Justice Kagan's explanation of the effective vindication doctrine in her dissent, the majority in Italian colors described the effective vindication doctrine as judge-made exception to the FAA, which serves to harmonize competing federal policies by allowing courts to invalidate agreements that prevent the effective vindication of a federal statutory right. The other cases...
Are we going to address footnote 5, though, that came after Italian colors in Viking Rivers Cruise?
Yes, Your Honor. In that case, again, the majority held in that case that the plaintiff's claims that were under California law could be submitted to arbitration. So in that case, if the Supreme Court was applying the effective vindication doctrine and applying it to state law claims, then it would have denied the motion to compel arbitration and would have allowed those claims to proceed forward in the court. That's not what transpired there. So the holding in Viking River has nothing to do with the effective vindication doctrine. And as I mentioned earlier, in Rogers-Rozier, this court noted that cited the footnote 5 of Viking River for a proposition that had nothing to do with overruling the effective vindication doctrine.
Not overruling the effective vindication
I'm sorry.
doctrine. I'm more so asking, did the footnote stretch the effective vindication doctrine?
And that's what I meant to say, Your Honor, by overruling. It was not this huge sea change to extend the effective vindication doctrine beyond protecting just federal statutory rights, which is the FAA's concern here, and extending it to state statutory rights. The other citations that Plaintiff's counsel was referring to, those cases involved loan agreements that had a governing law provision that only allowed for the application of tribal law. They didn't allow for the application of federal law. And that is why the effective vindication doctrine was applied in those instances, because there was a prohibition on applying federal law. Again, here there's been no sort of challenge of a specific nature to the delegation provisions. It's been overall a challenge to the loan agreements as a whole or the arbitration agreements as a whole. In Jackson v. Payday, which was referenced by Plaintiff's counsel, that too was a case in which you had a situation that involved a non-existent tribal arbitration program. So what they called for was an unfair forum, basically a non-existent arbitration that was going to be operated by the tribe. Nothing to be said about operated by the tribe, but the actual forum didn't exist. Here what we have is a fair forum with the AAA. We have the largest nation's consumer arbitration administrator, a fair forum. I see my time's up. If there's no more questions, and I'll
No, thank you, counsel.
stop my time. Thank you.
And thank you both for appearing today. The court will take the case under advisement. Thank you. We'll call our next case up for this morning, appeal number 242165, Mohammed El Shanobi versus Pamela Bondi. saw him just a moment ago. He was, okay, all right. We're going to take a quick 5-minute recess while we get him connected. All right, thank you.
And right now,
this honorable court is now in session. Please be seated and come to order.
All right, we are back on the record. And Mr. Noby, case number 242165, you may proceed.
Of immigration, they dated June 10, 2024. In our case, we are requesting only withholding of removal under the
Mr. Nobe,
Convention
now you're
against
coming
torture.
through. You were delayed a little bit. Do you mind restarting?
Oh, I'm sorry. Yes. Good morning.
Good morning.
Good morning. So this is our petition for review for the board decision of appeal dated June 10, 2024. Our main relief is withholding of removal under the Convention Against Torture, CAT, as well as deferral of removal, because my client or the petitioner is convicted of an aggravated felony. So the petitioner is a Coptic Christian from Egypt, and he has been persecuted by the Islamists in Egypt. The issue here whether substantial evidence support a finding that Mr. Ayad would not be tortured if forced to return to Egypt, and whether the persecuted he faced already was generalized evidence of human rights violation, or he was singled out as a Coptic Christian. In addition, whether the government or not was in acquiescence of the persecution. So the record shows that he was targeted twice in Egypt. One in 2012, he was beaten, he has injury. We submitted all the documents supporting that he was injured by the Islamists. And even after the President Sisi took over, and he was also persecuted by the same Islamist Islamist extremists, and his house was burned out. So it sounds very clear that he was singled out, and he deserved protection under the Convention Against Torture, not to be sent to a country where he will be persecuted. The main issue in this case, whether the government is in acquiescence of this persecution. And we can really, in Egypt, it's a government, very tight government, that will not help directly the Islamic extremists to persecute Coptic Christian. However, they want the...
Mr. Nobe, I'm sorry, Mr. Oshinobi, can you back up for a moment? I want to make sure that I understand what argument would we have to find that this issue, whether or not the application for withholding or removal was properly preserved?
Was properly preserved?
For us to be able to hear it,
I didn't get the main question. If you can please explain it for me or rephrase it to me.
Yes, Was this question properly exhausted below?
It was not the board denied application based on the government was not in acquiescence of the torture, and that's what the main issue, whether the government of Egypt is helping directly or indirectly the persecution of Coptic Christians.
And we might be missing each other because of the delay. So there's the withholding of removal, and there's the under the INA, there's withholding of removal under the Convention Against Torture, and there's also the deferral of removal. And I'm questioning on the first two, were those properly exhausted below?
Yes, they were both exhausted below, but however, we are not asking under INA. My client is not eligible under INA. We're only asking for CAT and deferral of removal, like withholding of removal under CAT and under the and deferral of removal under Convention Against Torture.
And so can you walk us through, in particular, the withholding of removal because he did not qualify protection under the Convention Against Torture? How was that properly preserved? Because we had some argument from the other side that argument was waived.
Yeah, it was, we did preserve it, and it's based on, we did preserve it in our brief, in our request first relief in front of the judge, immigration judge. and he came out with the decision, and the board came out with the same decision, that the petitioner was not singled out, and he was not. It was generalized persecution. So our main goal today is two issues: that be tortured or beaten or singled out twice in Egypt, once before the current government and once after the current government, and the government forcing Christian Coptic to not to pursue charges against this Islamic militias. It's indirectly acquiescence with these militias to persecute Muslims. So the government is not playing a direct role to persecute the Christian Coptic. However, by pushing them to go into settlement and not proceed charges and conviction against them, it's the main role that the government is playing to push Islamic militias to continue Islamic not militias, extremists, to persecute Christian Coptic in Egypt. So the records show that they were kept, they were interrogated. However, no charges was charged against them after the government did in fact pursue pressures and force whether keep them in the police stations, whether ask priests to come to the police station to put pressure on them so they don't charge the Islamist extremists. They don't charge them with the crimes they did commit against them. So we are praying that our appeal will be approved and granted, and remand this issue to the Board of Immigration.
Thank you, counsel. We'll
Thank you.
hear, yes, we'll hear from Ms. Farrell, I'm sorry.
Good morning, Your Honors, and may it please the Court. Corey Farrell on behalf of the Attorney General. I would like to start by kind of clarifying what is before the court. The immigration judge found petitioner statutorily ineligible for asylum, withholding of removal under the INA, and withholding of removal under the CAT based on his convictions, which he found to be particularly serious crimes. And the board, in its decision, the third paragraph of its decision on page 3, states that respondent, or petitioner now, has not meaningfully challenged the immigration judge's findings that his convictions for robbery in violation of an Indiana criminal code and sexual battery qualify as particularly serious crimes, and that he is statutorily ineligible for asylum, withholding of removal under the INA, and withholding of removal under the CAT. And petitioner did not raise that waiver finding in his opening brief. So therefore, the withholding is both unexhausted and waived. So this court is looking at the immigration judge's denial of deferral of removal under the Convention Against Torture. And the record here does not show that petitioner will be tortured upon his return to Egypt by or with the acquiescence of government authorities. Petitioner was targeted in the past by neighbors, private actors who were members of an extremist organization. The police previously acted on petitioner's behalf when his house was burned down. He reported the incident to the police. They accepted the report. They investigated. They did not arrest the perpetrators, and the evidence in the record shows that was because the perpetrators had fled. The country conditions evidence and the testimony of petitioner's own witness show that the government is taking steps to combat religious violence, and petitioner could also reasonably relocate to avoid the harm he fears, a finding which he did not challenge before this court. Accordingly, the record does not compel reversal of the immigration judge's denial of deferral of removal under the Convention Against Torture. This court has held that general violence is not enough to establish eligibility for torture convention protection. The applicant must show a substantial risk that the petitioner will be targeted specifically. And here, petitioner did not make that showing for several reasons. The immigration judge concluded that he did not experience harm so extreme as to compel a finding of past torture. The harm he fears is by private actors, not the government. He testified on page 333 to 334 of the record that he fears neighbors and Islamic terrorist groups. There is also no compelling evidence of government acquiescence in this case. There's evidence specific to petitioner's own experiences. As I noted, the authorities investigated when his house was burned down. And 3 of the people involved were actually later arrested due to their ties to the Muslim Brotherhood. There's also general country conditions evidence, which the immigration judge fully considered, showing that while there is violence occurring in Egypt, the government is attempting to take steps to combat that violence. And again, as I mentioned, petitioner could reasonably relocate to avoid the harm he fears. So while there is evidence of discrimination and harassment of Christians, as well as sectarian attacks by terrorist groups, the record also includes this other evidence. And based on this, it shows that authorities are taking steps to stop these incidents. Therefore, based on this record, there's no compelling reason to reverse the immigration judge's decision denying deferral of removal under the Convention Against Torture. If there are no further questions?
No, thank you.
Thank you, Your Honors.
Mr. El-Shanobi, any rebuttal?
Yes.
You may
Yes,
proceed.
please. Thank you. So the petitioner did in fact relocate to Cairo, and he lived there with his family. However, he was still harassed, and at the time he was relocated to Cairo, his house was burned out, and when he went back to check it and file the report, he was beat. So he did his best to relocate. And for the government acquiescence, the government of Egypt, it's its picture to be very clean in front of the international community. So I'm sure they will not be helping them. However, indirectly, by not charging these people and going after them, charge them, take them to court for conviction, this Islamic still until today persecute Coptic Christian. The country report exactly say that Christians, Coptic, are forced to enter into settlement. It's not direct, but it's indirect acquiescence of the government to allow these groups or extremists to keep persecuting Christian. Single out harm in the past twice, not one, twice. Once he was beaten, he was injured. He has injuries that we submitted. The second one in 2016, his house was burned down, his wife's clothes was torn, and he was beaten again. So that's obvious persecution, obvious torture, and he will face the same if he were to send back to Egypt, especially after living all this time in the United States with his family. So I will ask this order to be remanded to the BIA. Thank you.
Thank you, counsel. Thank you to both counsel. The court will take the case under advisement.
Thank you.
Thank you. The court now calls case number 24-1853. Our next case for the morning is Ruiz versus J.B. Pritzker. All right. And we have Ms. McDonald on behalf of the appellant this morning. You may approach the lectern.
Good morning, Your Honor.
Good morning.
May it please the court, Ann McDonald on behalf of appellant Israel Ruiz. In 2019, Governor Pritzker signed into law the Illinois Youthful Parole Law. The law provided parole opportunities to individuals who had served more than 20 years for certain crimes committed when those individuals were under the age of 21. The law was designed to align parole opportunities with advancements in science, demonstrating that the human brain does not fully mature until age 25. However, the law granted parole eligibility only to those individuals sentenced on or after its effective date in 2019. Accordingly, individuals like Mr. Ruiz, who were sentenced before the act's effective date, did not receive the same parole opportunities. There is no suggestion in the science that people's brain development differs based on the effective date of their sentence. Accordingly, Mr. Ruiz filed suit here in the district court, bringing two claims, the first under the Equal Protection Clause of the 14th Amendment, and the second pursuant to the 8th Amendment's bar on cruel and unusual punishment. The district court dismissed both claims and Mr. Ruiz appealed here. With respect to the equal protection claim, Mr. Ruiz agrees that rational basis review applies to his claims. His position is that he has sufficiently alleged that there is no rational basis to discriminate between individuals based solely on sentencing dates.
So he's accepting that he is not alleging some type of fundamental constitutional right or suspect classification.
That's correct, Your Honor.
Okay.
Yeah. He agrees that it's his burden to satisfy the rational basis standard and to allege and to present factual allegations rebutting any rational bases offered by the state or anybody else. And it's our position that he has done so. The district court rejected Mr. Ruiz's claims, relying on two rational bases that the court said provided a reason for the distinction. The first, administrative burdens on the court and prison system, and the second, the interests of victims. With regard to burden, the court erroneously held that prospective-only application was justified by that burden on both the court and the prison systems. However, there is no court involvement with parole. The parole hearings are handled solely by the Prisoner Review Board. And as such, the rulings that the district court relied on in emphasizing the court burden, U.S. versus Speed, U.S. versus Sanders, and other sentencing-related authorities are inapplicable.
Before we get to Speed, is there any concern that this claim should have been brought not as or under 1983, but maybe as a habeas?
This claim was brought only under the equal protection of the 14th Amendment.
Under 1983, but is there any suggestion or concern that this should have been brought?
That's not been raised at all, Your Honor, by the court or by the opposing party.
Are we attacking at all the sentence itself?
No, Your Honor. We're merely requesting that the statute and the parole opportunity as set forth in the parole law be allowed to be retroactive. We are not addressing his sentence. With regard to the burden that the district court noted, it sort of had two parts, the court burden and then the administrative burden. It's also Mr. Ruiz's claim that the court was incorrect to rely on burden to the prison system in light of Mr. Ruiz's well-pled allegations that the burden on the prison system would actually be greater to incarcerate individuals for decades, perhaps unnecessarily, as opposed to the cost of a handful of parole
Before we get
hearings.
to, we're kind of going into whether or not there's a legitimate government purpose. What do we do when we look at Speed in regards to the desperate treatment?
I'm sorry, Your Honor.
Speed, and how do we get around this notion that the desperate treatment is rational, the holding, or I guess the suggestion in Speed?
Yeah, so the issue in Speed related to sentencing retroactivity and the concerns there that are articulated in that court and by other courts evaluating the retroactive application of sentencing is that the burden on the court to hold resentencing hearings and to go back and have to reprocess where those hearings had already happened has been found to be a legitimate government interest. But here, the distinction is that this does not require any relitigating, any reopening of sentencing hearings. All that this law requires is a parole hearing by the Prisoner Review Board. And authorities like Montgomery versus Louisiana, the Supreme Court spoke to this and said, offering someone a parole opportunity does not increase a burden on the court system and does nothing to actually affect or burden a sentencing court.
But if we accept that the government interest in sentencing versus parole might be different, what would be the irrational, desperate treatment in regards to the date being selected by the legislators, similar to in the Fair Sentencing Act argument that was raised that there will some that will be affected, and that's in, I guess, using the words of Speed, there's no way around that.
Well, so here I think the distinction between sentencing and parole demonstrate that there is a way around it. It didn't have to be that not
the desperate
everyone.
Treatment.
Yeah, that didn't have to be the case because the parole hearings hadn't already happened like sentencing hearings had. It is very possible to just allow for this sentencing going forward, and it's not a rational basis to deny parole hearings based on that distinction. With regard to the concern for victim that the court noted, Mr. Ruiz, as noted in our briefs, argued that the act itself takes into account consideration of victim interests. And so the legislature has already built into the act a process for taking into account those victim interests and incorporating them and making sure they're heard. Moving on to the Eighth Amendment claim, the district court was also wrong to dismiss his Eighth Amendment claim. Mr. Ruiz alleged that it was cruel and unusual punishment to deny parole hearing in light of the new science on brain development and life expectancy in prison for individuals who are incarcerated since youth.
In here, are you basically asking us to extend Miller and Montgomery?
Whether it's an extension or just an application, what we're doing is saying Atkins and Montgomery recognized that how we evaluate cruel and unusual punishment is based on the norms that currently prevail. And Atkins says the clearest and most reliable objective evidence that we have of the norms are what the legislature does. And here we have the legislature saying we need to look at individuals who are 18 like they are 17. We need to look at individuals who have these long sentences because they might die in prison without ever being able to show they were rehabilitated. So we're just asking for that law to be applied to the science, which Mr. Ruiz pled in his case, demonstrates that it's more likely than not that he will die in prison before being able to demonstrate that he's not one of those exceptional cases where that is an appropriate determination to have made when he was only 18 years old. And defendants focus on this and try to distinguish cases like Montgomery by saying that Mr. Ruiz was 18 and not 17 and his sentence was not mandatory, but it was a discretionary term of years. But again, Mr. Ruiz specifically alleged in the complaint that that term of years for him, in light of how we understand sentences impact youth who are incarcerated for most of their lives, effectively means that he was a man condemned to die as a youth in prison, when the prevailing norms of our society demand that he be reconsidered as an adult and be able to demonstrate that he has been rehabilitated. And it's for those reasons, Your Honors, that we ask the court reverse the district court's decision and hold that Mr. Ruiz has stated his claims under both theories. I'll reserve my time. Thank you.
Thank you. All right, Mr. Rush?
Good morning, Your Honors.
Good morning.
Assistant Attorney General Caleb Rush on behalf of the defendants. What Ruiz is asking this court for is unprecedented. There's no case that supports that a statute prospectively altering parole eligibility or any prospective statute of any kind violates equal protection. There's also no case that supports that Ruiz's 40-year discretionary sentence is cruel and unusual punishment or otherwise violates the Eighth Amendment. Instead, parole laws are a matter of legislative discretion, and Ruiz's attempt to make this a constitutional question creates real risks of discouraging legislators from reforming or improving criminal laws in the future. Unless the court has a different preference, I'll start with the equal protection claim. Altering parole eligibility prospectively does not violate equal protection. Mr. Ruiz has not cited any case holding that applying any new statute of any kind in any field, prospectively only, violates equal protection. He fails to engage with the broad principles stated 100 years ago in the Sperry case, or 10 years ago by this case in the Gladney case, that when a legislature adopts a new rule and makes that rule, prospective only, it comports with equal protection. But the court can dispose of this case without ruling on these broad principles. It can rule more narrowly on the multiple rational bases that we've addressed in our briefing. I might focus foremost today on protecting victims' settled expectations. There's a big difference between victims under the old system who, when they saw the perpetrator of the murder sentenced and the judge and the prosecutor said, this defendant will serve their entire sentence in prison. There's a big difference between the settled expectations of those victims versus the new system, where we have victims who are told at the time of sentencing, well, this sentence, there will be a possibility of parole after 20 years. And the legislators, when they chose to make this statute prospective only, they focused on this, and they focused on their concern for victim settled expectations. And one of the multiple Illinois state cases upholding this prospective statute against an equal protection challenge also recognizes the importance of not destabilizing or nullifying the discretion exercised in charging and sentencing decisions. I understand that opposing counsel seeks to make an important distinction between sentencing cases and other cases that might look at more forward-looking measures. The distinction is not relevant here for equal protection purposes. For the reasons that I discussed, making parole available, in fact, is connected with destabilizing sentencing and affecting the expectations that were settled at the time of sentencing. But there's a more important point for equal protection purposes. Courts have explicitly recognized that making a statute prospective, even if it's for something that only affects future events, still satisfies equal protection. As far as I know, this question has not arisen recently has not arisen in this circuit, but Ruiz has not addressed decisions from other circuits upholding statutes that are prospective only against equal protection challenges when they affect forward-looking things like adjustments to parole eligibility, adjustments to sex offender registration requirements, or good time credits. No factual development was necessary or even relevant in this case because applying the 12b6 standard, taking the facts most favorably to Mr. Ruiz, he simply has not stated an equal protection claim. He has not addressed the many cases from this court affirming the dismissal of equal protection claims. He has not explained how this case is different from those cases. Flying J is a very good example of a case with a thorough discussion of how rational basis review is applied at the 12b6 stage. If I can move on to the Eighth Amendment issue. I'm not sure if Ruiz's Eighth Amendment argument is clear. His reply brief seems to raise for the first time before this court a claim that his sentence itself is unconstitutional. If that's his argument, it is barred by Heck and was required to be raised via habeas corpus. We didn't mention this in our brief to this court because this argument was not in Ruiz's opening brief. However, we did mention this point in our briefing in the district court. Leaving aside that threshold matter, on the merits, cases limiting juvenile sentencing differ from this case in three ways. They're about juveniles age 17 and under. They're about mandatory, not discretionary sentences, and they're about life or de facto life sentences. Any one of these reasons defeats Ruiz's Eighth Amendment claim. I might suggest that discretionary sentencing is the most straightforward way to dispose of this claim, because there's no dispute that Mr. Ruiz had a sentencing hearing where the judge exercised discretion, including considering Ruiz's age. And even in cases involving juveniles, even in cases involving life sentences, that kind of discretionary sentencing hearing is all that's required. I would point the court to the 2021 Jones decision from the U.S. Supreme Court on this point. That's also in our brief. Just one final point on the Eighth Amendment claim. We also have an argument from Mr. Ruiz about arbitrariness. This is not based on any authority that applies here. He only cites death penalty cases, and we agree that there is an arbitrariness principle in death penalty cases. But he ignores the cases, in this arbitrariness argument, he ignores the cases that we've cited that hold that the Constitution allows different sentences, different punishments for similar conduct. And that the standard that's relevant in non-death penalty cases is a due process standard that comes back to rational basis review. So I'll simply restate that this prospective statute is rationally related to several legitimate government purposes, including especially protecting the settled expectations of victims. And if the court has no questions, I'll ask this court to affirm the district court's judgment.
Thank you.
Thank you, Your Honors.
Ms. McDonald.
Thank you, Your Honor. I'd like to say that the theme of counsel's remarks are essentially what we allege was wrong in the district court, which is to ignore the well-pled factual allegations in plaintiff's complaint. And what Mr. Ruiz alleged with regard to equal protection, that there was no rational basis. And you can share the general principles that counsel outlined for cases going back 100 years on equal protection, but at bottom, the standard requires that Mr. Ruiz rebut offered rational bases, and the facts in his complaint demonstrate that he has. With regard to the Eighth Amendment claim in particular, counsel recited three things that he claims bar Mr. Ruiz's Eighth Amendment claim: that Mr. Ruiz was not a juvenile, that his sentence was not a de facto life sentence, and that his sentence was a discretionary one. Mr. Ruiz's factual allegations demonstrate that his brain is more like that of a juvenile, and that his sentence at 40 years is more like a life sentence, because the life expectancy of a person incarcerated since youth is 53 years, and he was sentenced when he was 18 years old.
He was sentenced when he was 20.
He was sentenced, the crime was committed when he was 18, yes. And so he's been in prison, he's been in prison since he was 18 years old. That's correct, Your Honor. And so what the legislature said here was that the individual who is a youth should have the opportunity after the sentencing hearing. And so noting, for example, that Mr. Ruiz's judge had the opportunity at sentencing to take into consideration his age does not fully address the issues that we've raised here, because what studies show us is that no judge, and what the legislature in Illinois noted explicitly in the legislative record, was that no judge looking at an 18-year-old can truly know that that person will not be rehabilitated, and that we know for sure that that person cannot be a contributing member to society. And so what we are asking is for this court to use those principles from Montgomery and from Atkins to look at this science and to say, because we now understand that that judge is not able to evaluate an 18-year-old and know whether or not they should spend their whole life in prison, that that person should have the opportunity to have a parole hearing where they can demonstrate they have been rehabilitated and they can contribute to life outside of prison. So for those reasons, Your Honors, we're asking reversal, and that Mr. Ruiz may continue to pursue his claims in the district court.
Thank you, counsel. The court will take the case under advisement, and we thank both counsel for argument this morning. All right, we'll call our last case for the morning, and case number 24-1865, 1866, 1867, and 1868. And I believe we have Ms. Kastanek as well as Mr. DeJulius. All right, and so you will approach the lectern. You go right ahead. If you'll give us just one moment. You may proceed.
Thank you, and may it please the court. The district court erred in excluding the expert meta-analysis and general causation opinions of Dr. Martin Wells. Pervading the district court's opinion was its view that Dr. Wells cherry-picked the studies for his analysis. She repeatedly accused Dr. Wells of transparently reverse engineering his analysis, and that accusation rests on core misunderstandings, both factual and legal. It rests on her misunderstanding of what part of the analysis must be objectively replicable. It rests on her misunderstanding of the role of the first expert report versus explanations that come later in time. It rests on her ticky-tack criticisms of Dr. Wells that veer into what this court in Manpower called the third level, kind of like the third rail of the L train. It rests on her flat disregard of Dr. Wells's sensitivity analyses. He ran 6 of them, which the district court did not at all engage in, quite inexplicably. And at the Bradford Hill stage, it rests on her complete misunderstanding of what a null result is. If the court will allow, I will start with the court's legal error in requiring objective replicability at the wrong stage of the meta-analysis. Meta-analysis has three parts, as you know. First, identification of the potentially relevant studies. That stage is not at issue here. Everyone agrees, including the defense, that Dr. Wells identified the complete universe of 36 studies that were relevant to his analysis. They don't identify a single study that he missed at that stage. The second step is selection of the studies then for the meta-analysis, and let me come back to that stage. The third step is the math to calculate an odds ratio. Step 3, the math, is what must be objectively replicable. So Borenstein says this very clearly. The statistical synthesis of the math must be transparent and objective. So in other words, the math must math. But the defense doesn't say here that the math in question that Dr. Wells used doesn't math. It all adds up. So let's step back to step 2, which is the selection of the studies that's primarily in dispute in this appeal. It makes no sense to evaluating studies for quality must be objectively replicable. Studies selection involves the exercise of scientific judgment. A meta-analysis involves picking the best quality studies, and judgments across biostatisticians that differ as to study quality, that's an everyday occurrence in this field. Dr. Wells here started off with 7 meta-analyses. 6 of them were published and peer-reviewed, and their reliability can hardly be questioned. The 7th was the meta-analysis that was conducted by the EPA, the systematic analysis. Every single one of those meta-analyses included different studies. This is very important. None of them included all of the same studies. Some included Liu, some excluded him. Some included Vandermark, some excluded them. And Dr. Wells's scientific method here.
Let me just make sure I have clarity on the point in regards to the methodology. So when you have the qualitative and you have the quantitative portion of the meta-analysis, what I've characterized in my head as the rubric, is the suggestion is that the rubric itself, does that have to be objectively reliable?
Of course it needs to be objectively reliable. What I understood the district court to say is that it must be replicable. And that's not a term that is easily transported to the quality determinations that are made with respect to studies. Let me take one step back and just talk about, I'm sorry, Judge, go ahead.
Didn't the district court also say that the omission of literature called into question whether a methodology was being followed at all? Or
Yes. Yes, Your Honor, and that's such a good point because it is what meta-analysis is. So on page 36 of her opinion, when she starts looking at the meta-analysis, there's a quote there that I just want Your Honors to focus on because she says, Dr. Wells, by conducting this meta-analysis, omitted a significant amount of epidemiological literature. Yes, he did. That's a meta-analysis. Everybody agrees it involves picking studies that meet criteria. And to Judge Pryor's question, I was going to walk through what those picking steps were from him because I think it makes the issues here very clear. So there were 3 steps.
Is there an explanation from, because the testimony fluctuated in a sense, don't accept that as what happened here, but we went from 36, to 11 to 7. And
to
so
8 to 7, Your Honor.
8 to 7. And so I'm trying to follow along with the opinion, page 36 in particular, as to is there an explanation using the rubric, using the methodology that Dr. Wells laid out? Is there an explanation in the record for the 36 to 11 using that methodology?
Yes, I would point Your Honor to the clearest explanation being in his rebuttal report. And let me walk through what he says there, and then we can draw it back to his earlier report if that's something Your Honor is concerned about. So a few steps. He starts with the 7 meta-analyses that I mentioned. Those are the meta-analyses that were done by biostatisticians that came before him in the field. He compiles this universe of 36 studies that, again, as I said, defense doesn't allege that there's anything missing from those 36 studies. Their expert created a list of 32, so their expert's list was even more exclusive than Dr. Wells. Dr. Wells then applies a two-step process to get to the 8 and then to the 7. The first step is to say, I am going to consider exclusion, inclusion criteria. He says this on the very first page of his very first report. I am looking at epidemiological studies that were case control in design that looked at paraquat and Parkinson's in an occupational setting, okay? So that's 4 of the criteria: case control, Parkinson's, paraquat, those are kind of obvious ones, occupational, and then the 5th one that he explains later on in the report is that they have to have sufficient data. Also kind of an obvious one because he's conducting a meta-analysis. Of course, there needs to be sufficient data. That took him down to 8 studies. So that excludes Shritha.
So from the first report to the rebuttal report, is he getting rid of the number 11?
Yes, he gets down to 8 by just applying those 5 criteria I just said.
I guess my question, what more directly pointed was, is there explanation from the record to explain the first report where he was at 11?
I think that he's asked about that in the deposition, and he explains that I got down to 8, and this is very clear in the rebuttal report, Your Honor. Okay. He says, Shritha, Poshu, those are cohort studies, and you know my epidemiological approach, which is a scientific debate in the field, is to not combine cohort and case control studies, right? Okay. And so he doesn't consider Shritha and Poshu and other cohort studies to qualify for his analysis.
All right.
Okay. Now at that point, he evaluates quality, and he omits only a single study for his meta-analysis, which is Vandermark. Okay, and he does so because Vandermark fails all of his quality criteria. And this is one thing that I really want to emphasize in this argument to make sure everybody understands is his sensitivity analysis that he conducts that the district court doesn't even mention. I went through the entire 97-page opinion yesterday to look for this, is that he conducts an analysis that takes his 7 studies, the one he thinks is greatest quality, he adds Vandermark in, and he comes up with an odds ratio of over 2.0. This is, I can give you a record site for it if you want one. That sensitivity analysis is at docket 4561-14, which is exhibit 13 to the plaintiff's Daubert briefing. As your honors know from the briefing, this appeal comes down in large part to the quality determinations as to Vandermark. So the district court thought that was cherry-picked. The defense claims that that's cherry-picked. That sensitivity analysis is Dr. Wells saying, look, I think I'm right about quality here, but I'm going to go the next step and do this sensitivity approach where I show you that decision didn't drive outcome. So sensitivity analysis is taking the methodology, making changes to it to test whether methodological choices drive outcome. His sensitivity analyses showed that it didn't. The same is true of the sensitivity analysis that he did for the EPA study. So figure 3 in his initial report takes the EPA's high and medium quality studies, and it does a meta-analysis on them, and it also finds an OR above 2.0. Again, the district court didn't address this, didn't grapple with it at all. She instead seems to misunderstand.
But shouldn't she not have addressed the conclusion and more so focused on whether or not the methodology that Dr. Wells articulated was reasonably applied?
Yes, she should have, but the point is, I mean, you're right, his methodology needs to be reliable. But what he's saying is, look, I'm testing this in various ways to show that the defense's criticism of his methodology is outcome-driven, which is the primary methodological issue here. Is it outcome-driven or not? I'm doing this as this extra step, abundance of caution, to show you that this isn't outcome-driven. My methodology is reliable. I'm following standard procedures in the field. And the defense expert, going back to Your Honor's question about whether this is, was appropriately disclosed and if the defense knew enough about it to be able to rebut and refute, the defense expert, Dr. Alexander, took Dr. Wells's analysis, knew enough about it, the studies excluded, included, the data he used, to be able to replicate it. And this is another thing that the district court misunderstood. So in footnote 46 of her opinion, she seems to treat the argument about Dr. Alexander as, well, their expert is unreliable, so it's okay if Dr. Wells's expert opinion is unreliable. No, that is not the import of this. It shows that his analysis was transparent enough that another expert was able to come in, do the meta-analysis. And what Dr. Alexander did is he swapped Shritha for Tanner, so quality determinations as to whether Shritha or Tanner, which used the same population, were more reliable. They swapped it, created an odds ratio below 2.0, and it just demonstrates that all of this was sufficiently transparent to be able to push the boundaries and to be able to refute and respond. This is a classic case of dueling experts that should have gone to the jury. If I may, I will address the Bradford Hill criteria very briefly, which is a final error of the district court. The district court imposed a weighting requirement for the Bradford Hill criteria that isn't traceable to any requirements in the law or the scientific literature. So as the First Circuit explained in Millward, no algorithm exists for Bradford Hill criteria. It's not conducive to ranking, and statisticians and epidemiologists agree. So Weed, another epidemiologist in the field, describes ranking as a matter of personal preference. The restatement says the same. Vicari and Breckeridge, which are peer-reviewed published studies, didn't engage in ranking. We cite testimony from another expert in the field in our reply brief, where he was asked about ranking the Bradford Hill criteria, and he says, I don't know of any epidemiologist who does that as a matter of practice. And it's yet again kind of another example of the district court getting over her skis and imposing bright line requirements that don't have a foundation in the industry and the field of epidemiology, just like requiring him to state in advance every bit of his analysis, even though Rule 26 doesn't require him to do so, and even though Rule 702 isn't keyed to any specific report by the expert. So if there are no further questions at this point, I'd like to reserve the remainder for rebuttal.
Thank you, counsel. All right, Mr. DeGiulio.
Good morning, Your Honor.
Good morning.
May it please the court, Lee DeJulius of Jones Day on behalf of the appellees. I'd like to start first with the meta-analysis, and the question here is whether the district court abused its discretion in determining that plaintiffs had failed to meet their burden to prove that Dr. Wells applied a reliable methodology. And there's three principal reasons why the court should be affirmed. First, Dr. Wells applied a holistic methodology. We had a report, we had a deposition, and plaintiffs do not contend that a subjective, holistic methodology is reliable under Rule 702. They start at the second report, the rebuttal report, and I'll get to that. But they never contend that the holistic methodology was reliable. Second, Dr. Wells, midstream, after he reached his conclusions, changed his methodology. He took away the holistic methodology. He repeated holistic more than 12 times in the deposition. If you go to essay 130 to 134, it's about 20 pages of testimony where he talks about the totality of circumstances, looking at all of the factors. He refused to provide any specific criteria. Then in the rebuttal report, he comes through with a 5 inclusion factor, 5 quality factor test that is nowhere to be found, that is irreconcilable with his holistic methodology. And you cannot change midstream after reaching conclusions. There's no argument by plaintiffs that it is scientifically valid, that it is a reliable methodology to come forward with conclusions and then decide your methodology. That's sentence first, verdict later. It's not allowable under the scientific method. And the third reason, Your Honor, is that Dr. Wells unreliably and inconsistently applied that 2-factor methodology. So in order to make his analysis work and to come back and meet those conclusions that he had already said in his first report and that he expounded on his deposition, he had to fudge the numbers. He admitted at his first deposition that Lou wasn't an occupational study, as he said it was required in his first report. He had to change and monkey with the participation rates. He first said in his deposition there is no required participation rate. In his rebuttal analysis, he said 60% is required. He had to change the diagnostic criteria to get Vandermark out and Liu in. That is not a valid scientific method.
Explain, looking at the Liu test, was there any participation rates reported at all?
For Liu?
Uh-huh.
No, Your Honor. Liu did not have a participation rate. Dr. Wells said he assumed it was 100% because the people who started finished. But under that theory, or that analysis or definition, Vandermark would also have 100% participation. They looked at apples to oranges. And Tanner, if you recall, did not have a participation rate either. It just said participation was good. But Dr. Wells didn't provide any knocks on those two studies. And so I think it's very important when you go back and you look at what's at issue here.
Is there any support for the notion that the subjectiveness of meta-analysis is kind of baked into the science? It's understood that the expert is permitted to use this methodology that is identified to somewhat consolidate studies from different areas. And so I'm concerned, looking in particularly 59 through 63 of the district court's opinion, did we merge into credibility in the sense that we're requiring and so I'm just trying to get clarity as to your understanding of the science of what part of subjectivity is permitted when employing a meta-analysis.
Absolutely, Your Honor. The first part of the meta-analysis has scientific judgment in it. The expert has to identify criteria upon which he will search the literature, upon which he will apply exclusion criteria in order to get down to the studies to include in the meta-analysis. That is absolutely correct, and there's a great deal of scientific judgment that goes into that. And the district court was very clear. She's not criticizing Dr. Wells for including Tanner or Liu and excluding Shrestha or Vandermark. It is the methodology by which he went about that analysis. And there is no scientific evidence. Plaintiffs have not offered any evidence that a holistic subjective methodology counts under the scientific method, that is somehow scientifically valid. What Cochran says, and you remember, Dr. Wells on essay 129 says, on following Cochran says, you have pre-specified written criteria upon which you will examine your studies.
But he provides that criteria in the rebuttal report.
Absolutely, Your Honor, but that rebuttal report is irreconcilable with his initial methodology, which is holistic. Look at pages essay 130 to 134. He repeatedly, over and over again, says there is no specific criteria.
But are we now questioning the credibility as to whether or not his first representation that it was holistic was somewhat of wasn't true, because you're coming back and reverse engineering and coming up with these factors, qualitative and quantitative, after the fact. So whether or not holistic was the wording was used, and Dr. Wells comes back and says it was holistic based on these factors. And
no, Your Honor.
Are we questioning the credibility?
No, Your Honor.
Allow me to finish so we can make the record. When we speak over each other, it gets jumbled.
I understand.
And so I'm questioning whether or not we're kind of stretching beyond what manpower allows when we're doing this, in the sense, and I see it here in the order.
Well, Your Honor, I think the clearest example, and you touched upon it, of why this is not a credibility determination, it's really taking Dr. Wells at his word. If you look at the first report, he has 111 materials upon which he considers. He then goes to 11 studies and determines from those 11, 7 studies will be part of his meta-analysis. That is his first report. That's his deposition. And those numbers are irrebuttable. 111, 11, and 7. His second report, his new analysis, his new methodology, he says, I start with 36 studies. He can't recall how he got to those 36 studies, but he goes from 36 to 8 and then to 7. Those are 3 different data sets. The numbers don't lie. He applied a different analysis in the rebuttal report. And so when he's talking about holistic, and the judge does a nice job, Judge Rosenstengel on pages 39 and 40 of her order of going through the times that Dr. Wells talks about holistic. It is not about a mechanical two-step analysis that someone can follow. It is simply, I look at all the factors in the study and I decide whether it's good or not. He at one point says, well, I don't have an algorithm, but I guess if I had an epidemiologist in a room, we could talk about it and probably come to the same sort of conclusions. That's exactly what this court in Zenith said is impermissible. It can't simply be expert, I say so. There has to be some sort of methodology.
Was she attacking the factors that he considered, the 5 factors that he considered, or was she attacking how he applied those factors?
Judge Rosenstengel said that his methodology itself was unreliable. Whatever the outcome came to, it was unreliable because he started with one methodology, he changed methodology, and then he inconsistently applied that methodology. And that is perfectly consistent and fits right in with manpower. I mean, the court mentioned manpower earlier. Manpower,
would we have to overturn manpower?
Absolutely not, Your Honor. Absolutely not. Manpower says that on page 808 of its opinion, the data selection is inseparable from the methodology. That the methodology and the data selection are separate. They're wholly different.
You beat me to it.
I know, Your Honor. Thank you. Thank you. I appreciate you would have corrected me. In this case, there is no separation. The methodology is the data selection. Counsel stood up and she said there's 3 parts of a meta-analysis: identification of the study. Dr. Wells said he didn't know how he got there, and if you go to A58, there's that quotation there. She said the selection of the study, the meta-analysis that we're talking about, and then she said the objective portion, the math at the end. Well, I want to point the court to Essay 408, where Dr. Wells says he doesn't actually do the math. That's not something he does. He does the meta-analysis. And so when you talk about how Dr. Alexander could replicate the work that Dr. Wells did, it's because it simply is a math. It's literally a computer program that is plugged into confidence intervals and participant studies, members, etc., a certain data pool, and it prints out the numbers. Both experts use the same computer program. That's not what this is about. It's about the methodology in selecting those studies, in determining what goes into the meta-analysis. And that, unlike manpower, is not separable. It is one and the same. The methodology is the same. I'd like to turn, unless there's questions on the meta-analysis, I'd like to turn to Bradford Hill. On Bradford Hill, Your Honor, the district court, the courts have recognized repeatedly that Bradford Hill is inherently a squishy type of analysis. It basically requires experts to look at 9 different factors, determine based on those factors whether or not causation exists. What the courts have repeatedly done, including Millward, which counsel cited this morning, is require an explanation as to why those factors are met. And if you look at Dr. Wells' initial report, essay 20 to 24, is the entirety of his Bradford Hill analysis. He only touches upon one side of the issue. And what the Bradford Hill requires is a totality of the evidence review. A totality of the evidence review. That means you have to look at the positive and you have to look at the negative. And what Dr. Wells does is he just looks at the studies that support him. When you look at dose response, he looks at Tanner, he looks at Liu, he cites a study called Furlong. He doesn't ever address Shrestha. He doesn't ever address Pouchet, Vandermark, which find an inverse dose response. That is to say that the more paraquat one uses, the less likely one is going to have Parkinson's disease. That is a significant issue. He ignores it. He doesn't address it. When you look at strength of association, He looks solely at his meta-analysis. There's 7 studies in his meta-analysis. 5 find there's no association, significant association, between paraquat and Parkinson's disease. He says, I just look at the meta-analysis. I don't have to look at anything else. He doesn't look at Shrestha. He doesn't look at Vandermark. He doesn't look at Pouchet. He only looks at one side of the issue. So in order to have a valid totality of the evidence review, he's required to go back and he's required to look at all of the evidence and apply that evidence in a reasoned way. He never did that here. District Court tried to look at both reports, tried to examine and give him the benefit of the doubt that I'll look at what you've done here. There isn't an explanation as to why those factors, if you looked at both sides, come out the way they do. Your Honor, if there's no further questions, okay. Thank you. This court should affirm the court's abuse or its use of discretion in this case. Thank you, Your Honor.
Thank you. Counsel?
Briefly, Your Honor, let me start with Bradford Hill and this idea that he only picked positive studies. It's factually incorrect. It misinterprets what Dr. Wells meant by null. Null means it cancels each other out. He didn't disregard negative studies. What he disregarded, or what he chose not to consider, consistent with scientific literature, were results where the confidence interval spanned 1.0. So below 1.0, there is an adverse relationship between paraquat and Parkinson's. Meaning the other side, he or she is winning, and there's also an option in the middle, right? That is what Dr. Wells is saying about the null results, that those don't tell me anything because they could be negative, they could be neutral, they could be positive. And the district court, once again, misunderstood that. Judge Pryor, I think on the meta-analysis, you're exactly right. The district court stretched manpower beyond its proper role here, or 702 beyond its proper role. The defense complains that Dr. Wells from the beginning said his approach was holistic. It was as to the quality factors, and holistic doesn't mean subjective. It means that as to the quality factors, not a single one was dispositive. At the inclusion-exclusion criteria, which is what led him to those 8 studies, it wasn't subjective, it wasn't holistic. He didn't include studies unless they were case control, evaluated Parkinson's and paraquat, had sufficient data, and were occupational in nature. There wasn't lethal inconsistency in his positions with respect to that. If I can take one moment and address occupational, it is very important to keep in mind that as to occupational, he used an OR from Liu that was specific to use of paraquat, occupational meaning related to activity. The district court misunderstood occupational as workplace related rather than a broader definition. Think occupational therapy as related to activity as distinguished from community exposure. And when you understand occupational in that way, you will see that there's not lethal inconsistency with respect to how he approached these various factors. Thank you. If there are no questions from the panel, we would ask that you reverse.
Thank you, and thank you to both counsel. Those are all our arguments for this morning. The court will take the case under advisement. The court is in recess.